Hi, my name is Krystal Carvajal and I am a rising 3L student at Rutgers Law. This video is a Know Your Rights guide to the civil commitment process. There are two important things to note from the outset. One, the jurisdiction is New Jersey, and two, the information pertains to adults, not minors. In my opinion, mental health is far too often overlooked and underaddressed. That said, I'd like to take this time to thank you for watching this video and for educating yourselves on this very important topic. I would also like to add that I took some notes, so if it appears as though I am reading from my notes, it is because I am. But please feel free to follow along with the PowerPoint that is provided to you on this site. To start, I'd like to give you an overview. When it is alleged that an individual is in need of commitment, it is necessary to obtain an order of temporary commitment to detain 1. A person involuntarily confined following an assessment at a screening service, or 2. A person not presently hospitalized or confined for treatment of mental illness, such as an independent application. As you can see, there are two methods to initiate an involuntary commitment, the first being a screening service referral. Most applications for an order of temporary commitment are brought by a short-term care or psychiatric facility or special psychiatric hospital to which an individual has been involuntarily admitted from a screening service referral. Such a person will have recently, within the past 72 hours, undergone an assessment at a screening service. The person may have voluntarily entered the screening service or may have been taken there involuntarily by a family member or law enforcement officer. The law enforcement officer may have acted upon personal observation or the certification of a mental health screener who performed a screening outreach visit. At the screening service, a mental health screener will have first assessed the person and completed a screening document. The person would have been next assessed by a psychiatrist or other physician who will have completed a screening certificate, concluding that involuntary commitment was necessary. Upon completion of the screening certificate, the person would have been involuntarily admitted to a short-term care facility, psychiatric facility, or special psychiatric hospital determined to be appropriate by the screening service. A second screening certificate will be completed by a psychiatrist or physician at the facility. If continued involuntary commitment is deemed necessary by the patient's treatment team, the facility or hospital must initiate court proceedings. A person cannot be detained at a short-term care facility for more than 72 hours from the time the screening certificate was completed. That bit of information is very important, so I will repeat it. A person cannot be detained at a short-term care facility for more than 72 hours from the time the screening certificate was completed. Accordingly, the facility must obtain an order of temporary commitment within 72 hours or the individual must be discharged. Please note that this 72-hour requirement does not apply to the initial screening document. The second method to initiate an involuntary commitment is an independent application. If a screening service procedure is not used, proceedings for involuntary commitment may be initiated by filing an application supported by two clinical certificates, at least one of which is prepared by a psychiatrist, stating that the individual is in need of involuntary commitment. The originals must be filed with the court with copies sent to the office of the county adjuster. If proceedings are instituted by independent application, there must be no involuntary commitment prior to the entry of an order of temporary commitment by the court. Now let's talk about voluntary patients requesting discharge for a moment. If a voluntary patient at a short-term care facility, a psychiatric facility, or a special psychiatric hospital requests to be discharged and the patient's treatment team is of the opinion that involuntary commitment is necessary, a court order for temporary involuntary commitment must be obtained. This situation may occur at the hearing for voluntary patients. For example, the patient states she, he, or they wants to leave, or the judge ascertains that the patient is either not truly at the hospital on a voluntary basis or lacks the competency to understand what voluntary means. Without a temporary or final court order, the patient must be discharged within 48 hours of the discharge request or at the end of the next working day following the request, whichever is longer. In support of a petition for an order of temporary commitment, the hospital or facility must submit an application for commitment and 2 clinical certifications prepared and executed by physicians, at least one of whom must be a psychiatrist. In the event the patient's treatment team includes a psychiatrist, that psychiatrist should prepare and execute one of the certificates. If the order for temporary commitment is signed by a judge, a final hearing should be scheduled within 20 days. Now let's move along to the contents of the certificate. The 2 certificates required for commencement of an action must state with particularity the facts upon which the psychiatrist, physician, or mental health screener relies in concluding that 1. The patient is mentally ill, 2. The patient is dangerous to self or others or property as a result of mental illness, 3. The patient is unwilling to voluntarily accept treatment, 4. The patient needs treatment, and 5. Other less confining alternatives are not appropriate or available to meet the patient's mental health needs. Now, there are persons disqualified from signing these certificates. Put differently, no certificate may be executed by a person who is a relative, by blood or marriage, of the person being examined. If a screening service referral is used, the same psychiatrist may not sign both the screening certificate and the clinical certificate unless that psychiatrist has made a reasonable but unsuccessful attempt to have another psychiatrist conduct the evaluation and execute the certificate. Now let's review the requirements for entry of order of temporary commitment. Let's start with the referral from a screening service. The questions that you ask yourself are: has the individual been detained in a facility for more than 72 hours from the time the screening document was completed? If yes, the order of temporary commitment cannot be entered. Has the screening document been completed? If no, the application is not complete and the order should not be entered. Has a clinical certificate been completed by a psychiatrist or physician affiliated with the screening service? Has another clinical certificate been completed by a psychiatrist or physician on the patient's treatment team? Was at least one of the 2 submitted certificates completed by a psychiatrist? If not, the application is not complete and the order should not be entered. Were the screening document and the clinical certificate completed by the same psychiatrist? If yes, has the psychiatrist made a reasonable but unsuccessful attempt to have another psychiatrist conduct an evaluation and execute the certificate? Is any person completing a screening document or certificate related by blood or marriage to the person being examined? If yes, the document may not be accepted. Now let's review the questions as it pertains to an independent application. Are there 2 clinical certificates completed by physicians, one of whom must be a psychiatrist? Are the certificates prepared and executed by a psychiatrist or physician who has conducted an examination of the person within 3 days of presenting the person for admission to a facility? If no, the application must be rejected. If the application is made for a voluntary patient who is seeking to be discharged but whose treatment team believes is in need of involuntary commitment, has the patient been detained for more than 48 hours after the request or until the end of the next working day, whichever is later? If yes, the order of temporary civil commitment cannot be entered. Now let's move on to the commitment hearing. The burden of proof rests with the state. What does this mean? The state must demonstrate by clear and convincing evidence that the patient needs continued involuntary commitment. Evidence is clear and convincing when it produces in the mind of the trier of fact a firm belief or conviction As to the truth of the allegations sought to be established, evidence so clear, direct, and weighty, and convincing as to enable the fact finder to come to a clear conviction of the truth of the precise facts in issue. Now, the decision by the court. Upon the conclusion of an initial hearing for an involuntarily committed patient, the court must issue an order from among the following four options: 1. Continuing involuntary commitment. 2. Finding the patient does not need continued involuntary commitment and entering an order of discharge. 3. Discharging the patient subject to conditions recommended by the facility and mental health agency staff and developed with the participation of the patient. 4. Authorizing the conditional extension pending placement of the patient's hospitalization when a patient otherwise entitled to discharge cannot be immediately discharged due to the unavailability of an appropriate placement. Now, importantly, the patient's rights. The patient is entitled to an orderly and dignified commitment hearing. The purpose of the commitment hearing is to determine whether the individual before the court meets the legal standard for commitment. An order of commitment should be entered only after a careful weighing of the facts and application of the dangerous to self or dangerous to others standard. Strict adherence to that standard is required. The decision to commit an individual, if made, deprives the patient of his, her, or their most fundamental legal right, liberty. Accordingly, maintaining a solemn and dignified judicial atmosphere is essential. If the patient does lose his, her, or their liberty, he, she, or they should feel that he, she, or they had a full and fair hearing, and that it was a court proceeding. Utmost care should be taken to ensure that the atmosphere remains judicial and that the participants do not view the proceeding as akin to a medical review or a treatment team meeting. Because involuntary commitment to a mental health deprives the committee of important liberty interests, the procedural and substantive safeguards established by statute and court rules must be scrupulously followed. It is inappropriate for the judge to advance the case for commitment because it places the judge in the role of an adversary rather than that of a neutral decision maker. And so, the judge presiding at the hearing should wear judicial robes, have all witnesses sworn, insist that those in the courtroom not interject or raise their hands to add something they think may be helpful or background. All witnesses should testify in turn, and all testimony should be elicited by counsel. The judge should also remind court personnel, if necessary, that the dignity of the individual patient must be respected at all times. Odd or unorthodox statements by a patient are not justification for laughter or snickering. The judge must also refrain from lecturing the patient. Now, the patient's Bill of Rights. This comprehensive set of rights, while not directly related to the question of whether the patient is mentally ill and dangerous to self or dangerous to others, may be raised at a treatment hearing, and commitment judges should be generally familiar with the bill's provisions. The key features include: commitment in and of itself is not a basis for depriving a patient of basic civil rights such as voting, driver's license, and other licenses, permits, or privileges of citizenship. The right to be presumed competent. Commitment for mental illness does not of itself give rise to a finding of incompetence. The right to be free from unnecessary or excessive medication. Medication must not be used as punishment for the convenience of staff, as a substitute for a treatment program, or in quantities that interfere with the patient's treatment program. Voluntarily committed patients have the right to refuse medication. The right to be free of shock treatment, psychosurgery, experimental research, or sterilization, unless the patient gives express and informed consent after consultation with counsel. There is an exception. If a patient has been adjudicated incompetent A court of competent jurisdiction can order these procedures. The patient, however, has the right to counsel and the right to a plenary hearing before any of these can be administered. They also have the right to communicate with an attorney, a physician, or the courts. Other rights include the right to privacy and dignity, to treatment in the least restrictive conditions necessary, to keep and use personal possessions, to see visitors each day, to have access to telephones and letter writing material, to regular physical exercise, to be outdoors at frequent intervals, to practice the religion of the patient's choice, to receive prompt and adequate medical care. These rights can only be denied when the director of the program determines it is imperative to do so, and a notice of denial filed in the patient's treatment record contains an explanation of the reason for the denial. Rights denial must not exceed 30 days unless renewed. Notice of rights denial must be given to the patient's attorney, and every individual who is mentally ill is entitled to medical care and other professional services in accordance with accepted standards. The right to have examinations and services provided in the patient's primary means of communication, including as soon as possible, the aid of an interpreter if needed, is also an important right. The qualified interpreter should be provided for the deaf or hearing impaired, and for individuals who do not speak English as their primary language. To conclude, the governing statute is NJSA 30:4-27. I will repeat that. NJSA 30:4-27. Thank you and best of luck.